Have you ever wondered how criminal charges are filed? Well, stay tuned because I'm going to tell you how. This is Crim Law 101. I'm your professor and class is in session. My name is Jamahl Kersey and I'm a criminal defense attorney in San Diego. And in this video, I'm going to explain how criminal charges get filed in court. Let's start with police investigation. One of the ways police investigations are initiated is in response to a 911 call. Someone calls 911 with an emergency, the dispatcher puts the call out, and officers respond to the scene. The officers take the statement of the reporting party and any witnesses. Crime scene investigators may take photographs, collect evidence, or shoot video of the scene. Later on, a detective may follow up with any witnesses to confirm or clarify their statements. Reports are prepared and the evidence collected is compiled. The police then turn over all of the information, the reports containing the witness statements, videos, photographs, etc., over to the DA's office. From there, an issuing DA reviews the evidence. The police will generally recommend the charges which should be filed. The issuing DA reviews the evidence to see what, if any, charges should be filed. And this is done by looking at the elements of a crime. For example, a robbery in violation of Penal Code Section 211 has two elements. One is the taking of property, and two, using fear or force. A burglary in violation of Penal Code Section 459 has two elements as well. One is the entry of a building, and two, with the intent to commit theft or any felony therein. And so the DA is analyzing the facts to see which charges she believes can be proved beyond a reasonable doubt. Sometimes additional evidence is needed in order for the DA to reach the conclusion that she can prove her case beyond a reasonable doubt. In this instance, the detectives would actually be called on to conduct further investigation. In other occasions, even though the detectives make a recommendation for certain charges to be filed, the DA does not believe that the charge can be proved beyond a reasonable doubt and declines to file the charge. An important distinction is the fact that law enforcement merely needs probable cause in order to arrest somebody for committing a crime. Probable cause is a relatively low standard. A DA must be confident that she can prove her case beyond a reasonable doubt. And this explains why sometimes people are arrested for a crime but don't actually get charged in court, or why in some cases charges get dismissed after they've been filed. Assuming there's sufficient evidence justifying criminal charges, the next step is the drafting of a document called the complaint. The complaint has the defendant's name, date of birth, and booking number on it, along with a case number. It lists each of the charges and allegations against the defendant, along with the sentencing ranges for each charge. The complaint is then filed in court. The next step is the defendant's initial appearance, which is called the arraignment. And in the arraignment, the accused is formally read the charges against him and he enters his plea. You can check out my video on where I explain what happens at the arraignment. Well, that's a quick explanation on how criminal charges get filed in court. I hope you enjoyed this video. If you did, please show us some love and hit the like button. If you think someone might find this information useful, please share it. Thanks so much for watching. This was Crim Law 101, and I'm out.